I'd like to introduce Jim Hingeley, who's going to be our moderator tonight. Jim was one of the organizers of this panel, which he and Cynthia Neff from the Legal Aid, former director of the Legal Aid Justice Center, convened for us. And Jim will be introducing the speakers.
Welcome again. I want to introduce the speakers. I'll introduce them all at one time, and then we'll just go through the panel as they make their presentations. Chief Brackney will be our first speaker this evening. Chief Brackney became the chief of police in Charlottesville in June of 2018. So coming up soon, she will have been here for 2 years. It's been an exciting 2 years for her, I know, and she's going to fill us in on some of the things that are happening in Charlottesville. She's a 30-year veteran of the Pittsburgh Bureau of Police, and she's also the former chief of police at George Washington University. She has both a bachelor's and master's degree from Carnegie Mellon University and a PhD from Robert Morris University. There are many distinctions that she has, and I'm going to skip over those right now in the interest of giving all of our panelists and you, the audience, more time for presentations and questions. But one thing struck me about her biography, and that is because of her work in social and racial justice, Dr. Brackney has been granted a fellowship to the Carnegie Mellon University's Institute for Politics and Strategy, where she specializes in the influence of race on politics and policy. So that's something that really this community is very interested in, and we're very anxious to hear from Chief Brackney on all of these issues, but especially the influence of race on politics and policy. The next two speakers, I'm going to introduce or talk a little bit about both of them at the same time because they have much in common. Joe Platania, who is the Commonwealth's attorney in Charlottesville, and Elizabeth Murtagh, who is the public defender for Albemarle County and Charlottesville. So they have some things in common. Both of them are graduates of Washington and Lee Law School. Both of them teach clinics at the University of Virginia. Joe, not surprisingly, the prosecution clinic, and Liz, the defense clinic. Both are members of the Virginia Criminal Justice Conference. And without getting too much in the weeds here, let me just say that the Criminal Justice Conference in Virginia is an organization of people coming together to solve criminal justice problems. And they come together from the academic side, from the judicial side, from defense side, and prosecution. So it's a real exercise in collaboration and problem solving. So that experience that both of them have tells you a lot about the kind of people that they are. Both of them have represented people charged with capital murder, and I think that's pretty unusual for a prosecutor, not so unusual for a public defender, but they have experience in that most serious kind of criminal charge that we have in Virginia. Another thing that they have in common is they both worked for me. Joe started working for me in 1999, and Liz started working for me in 1991, so we go way back. Joe didn't stick with it.
Neither did you.
Nor did I. Well, I stuck with it a little longer. But anyhow, Joe, in 2003, after working for 4 years as an assistant public defender, went on to the Charlottesville Commonwealth's Attorney's Office as an assistant, and then in 2017 was elected as the chief prosecutor in Charlottesville. Right now, Joe is the board president of the Charlottesville Albemarle Drug Treatment Court, and Liz Murtagh has, over the course of her career, been very active in the drug treatment court as well. So, that being said, I think we'll head right into the presentation. We're going to do roughly 20 minutes each, and I'm going to ask for you to hold your questions rather than at the end of each panelist asking questions, because what my concern is that we may end up spending all of the time with one panelist. So hold your questions as we go through the panel. We're going to start with Chief Brackney and then go to Liz and Joe after that.
So thank you very much for inviting us. I thought the wealth and the breadth and the depth of the information and the panelists that you have in front of you, as well as the necessity for this type of conversation about where we are in the criminal justice process as a system. And for me, it was really important to first start talking about what is the current state of policing, either nationally or here. And what I was struck by, even as I just returned from Chicago, as we were talking about divided communities, and what does that look like when communities are torn apart by some issue, whether it's around racial lines, racial divides. Oftentimes it's about officer-involved shootings of unarmed black men in the communities. It also has a lot of historical inequities and institutional inequities that we find ourselves facing, and then wrestling with these dichotomies, as I like to think about it. When I think about the current state of policing, these are the type of images that are often assailing us, right? We see this one image of officers out in the community. They're heavily involved in the community doing outreach and those non-traditional things that we think about when we think about policing. There's a lot of volunteerism, mentoring, and things of those natures. And there's a lot of one-on-one interactions. At the exact same time, we also are flooded with these types of images of what policing looks like in the United States. It's often very militarized, right, which is an interesting juxtaposition between the first ones where you see a lot of community outreach, and then you see these very militarized images of those interactions with our citizens. The thing that makes it really so stark for me as I look at these images is these type of images, again, we're then flooded with more images of these officers doing outreach in very soft ways in which they engage the community, whether they're reading with individuals, helping them learn, whether they're practicing, whether they're supporting marginalized communities like the LGBTQ plus IA plus community. Some of these things that you see one of our officers just grabbing a child who looks like they need some support and comfort and to be hugged, and then we're met with another image that looks something like this. And this image, if you remember this one went national. This is from Charlotte, North Carolina in 2016 after the shooting of an unarmed black male there, in which they took to the streets. And this individual here is Braxton Winston. Braxton Winston took his shirt off as they were being peppered with OC spray and gas spray, and he took his shirt off to cover his face so that he could at least be still out in the streets. And then as he's standing there as vulnerable as he could be with nothing on him, including bare-chested, he's faced with a very large military presence. I met Braxton this past week. And it was interesting the way that I met him is he was part of the Charlotte's Divided Communities Project. And what's also striking about him, as I did an e-introduction, he ran for city council in the fall of 2017 after this event. So this had occurred and was elected as an at-large member to city council. The interesting tagline is literally he was in the face and one of the first persons arrested in defiance of police, and now he's part of the supervision of the policing community here. So I did an e-introduction between him and our mayor, who had very similar pathways by which they came into their governmental service, and to see what that looked like. Why this was important for me is because it's important for me to constantly always remember the images that are in our heads as we move back and forth between these type of images, which we see all over the place, and also these type of images. And why that is important for not only our police community to see, but also for the rest of the community, that there is right now just a dichotomy between what we believe policing is and should be, and there doesn't seem to be anything in the middle. We don't see those images of what goes on in everyday life in policing and in the policing community. What we also don't see It is also the heartbreak on each sides of the community when there are these negative interactions with the policing community. And we won't talk about it because I don't know who's in the audience, but we are in court right now because of an officer-involved shooting, which one of our officers was shot. So we don't hear those. We just often hear about one or the other. And keep these images in your mind as we talk about the law enforcement community and the policing community, and as we are shifting under these 21st century policing models into not community-oriented policing, problem-solving policing, but relational policing. And that's what will help us, I believe, move from one image to the more frequent images of how we engage in the community. Currently, if you go on any social media, there is a societal view of policing right now, that we are part of every negative system and part of a orchestrated system for the police to be used as an introduction into the criminal justice process or the criminal justice system. Oftentimes, we're associated with the school-to-prison pipeline as being that first person on the forefront of introducing young juveniles, particularly our black males, and using that system to criminalize disciplinary behaviors in the school system. We're often thought of as this thin blue line that we don't ever cross, right? We protect and we circle the wagons, even around those cops and those police officers who we know or in that occupation are often perceived as being corrupt. You hear stop and frisk, and it was really highlighted under New York, and then those are part of the political conversations today about weaponizing police officers against communities. The shooting of unarmed black and brown men, every single day, there is some image in which we can name person after person who has been part of those. And thus the hashtag say their names. What does that look like when you have to say Michael Brown's name? What does that look like when you're talking about Eric Gardner, Sandra Bland? And then, these are names we can all repeat, and what does that bring with it, those images, even in my own hometown of Pittsburgh, of Anton Rose, and the shooting there, and then the officer being tried, and then not convicted of shooting an unarmed juvenile in the back and killing him. Disproportionate minority contacts. When you hear that, that's the only thing you think about is policing and the police officers introducing at the very first level into the criminal justice system. Racial profiling, extensions of governmental oppression, overcharging, and then also the accusations of over-policing and under-policing our vulnerable communities, particularly those communities that are black and brown, and those communities that are poor, and those communities that cannot and aren't able to defend once they are introduced into the criminal justice processes. That is currently the societal view of policing. It is not a very positive view of the policing community. However, what I'm here to remind people of is the definition of what policing was meant to be. It actually comes from the Greek word of policing that it was then, as I say, hijacked through the Latin community. And it originally stood for citizenship. It was part of the administration and the civil polity, and I may say that wrong, but that basically means the government and how the government was formed. It was not meant to be in its current form or often in its current reiteration. As Sir Robert Peel says, that police officers are the only persons who are paid to do what we should be doing as society as a whole, right? That we shouldn't have the need for a paid entity. We as society should be policing ourselves. However, that's not what's occurring, and there's a reason that doesn't often occur. As communities in our neighborhoods have been weakened, so have their influences as a means of societal control. And often that has a historical and institutional context to it. That is, that we are now more dependent on policing, and they're now doing and asked to do these near impossible tasks. And those near impossible tasks that we are often faced to do is a glimpse of what we do on a daily basis. And it is not often what you would expect that we were doing. we now on the majority of our calls have a mental health component to it, a mental health crisis component to it. That is not meant to be part of the policing system. But somehow now, because of systems that have been removed from, and funding often removed from the mental health field, the ability to get quality care is often at the expense of putting them, or what they might get care from, is in a criminal justice or a jail system. That is a sad, reflective state of affairs when we no longer have the ability, so that someone believes they need to leverage the criminal justice system to get the type of help they would need in their communities. The opioid epidemics and the other epidemics. Now officers are now being asked to carry Narcan and all the other medical equipment that they would need to help resuscitate a person. Those are not the initial kind of things that an officer thought they were doing, or their initial jobs would have been as an introduction into the criminal justice system. Family mediation. We are doing training in facilities on how to keep your facility safe. Responding to your numerous accidents. We do enforce laws. We give transportations. We actually do that. But if you look at that list of what we would think a police officer is supposed to do versus what they are actually doing, the majority of what they are doing are responding to, as I say, those social service type of interventions. Lots of community events. I see some of you here that I spent the weekend with. As we renamed Winneba Street down at 6.5, and what that meant to our sister city commission and community. You see officers at all of these type of events, and there is a demand for them to spend more times out in the community one-on-one. We'll hear, we want you walking a beat in the community. There was a time when officers knew everyone in their community and everyone knew the officers. And I often have to reflect in my 30 years of policing, there was a time when officers were out on the beat. That makes sense, right? But there was also a time when the community was out in the street as well with them, right? They weren't out there in isolation. Now we're demanding that they're out there, and the community doesn't necessarily, they're not out there supporting that as well. So when we say there was a time that they knew the officers, well, there was also a time the officers knew the community. And the community is a very transient community. It's a very mobile community than when we had more than 40 or 50 years ago, when we often are very nostalgic about what does policing, did it used to do then, and what does it do now? So that is some of the things I look at when I'm thinking about what is the current state of policing and how do we move forward. So policing is actually, and should be, the first initial stage of the criminal justice process. But for some reason, there is a misconception that policing is the criminal justice process, and that we have a lot more power and authority than we actually do. Policing is nothing more than enforcement of the laws that are currently on the books. And we'll talk about that, and we have two very esteemed public defenders and prosecutors here to talk about that. They don't have the power to create laws. They don't have the power to do anything else except to enforce the laws. And that is even heavily regulated by the magistrate's office and by the Commonwealth's office in terms of what we can and should be charging. The officer just cannot arbitrarily just decide to charge something and then it finds its way on the Commonwealth's attorney's desk. That has to go through a judicial process or a judicial review, and that review is at a level of a magistrate or the Commonwealth's attorneys or whoever is that's present that says that you do have the ability to go ahead and move forward with that charge. What's so important about it being the initial stage of the policing process or into the introduction is a distinction as to whether the officers can do something or whether they're the ones doing it themselves. I've broken this up into those non-officer initiated responses. And that's important to make that distinguish between those two. Non-officer initiated responses are those responses where the officer is either sent there through 911, they're sent there because there is a warrant that may exist. Somebody flags them down on the street. Somebody asks assistance. Somebody will walk into the police station and say that I need your support. I need whatever those resources you can bring to bear. And that's important that we know that when those calls come, the officers they can't refuse that. Dispatch tells them to go, and they go. I'm sure some of you think they don't get there as fast as you would like them to get there, and there are times when you think they don't show up at all. But it is dispatch who is the person, and that's a civilian call to your 911 that will then tell the officers where they need to go in response to whatever that issue is or that call is for someone who may need our support. Those officer-initiated responses is really where I have been spending a lot of our time as we talk about the current state of policing. If you want to talk about what does policing look like, and I'll move on to this next one and it'll help you with it. When you want to talk about what does that look like, this is the area, the officer-initiated, where we often have fallen short and lost the trust and legitimacy in the communities, and how persons have been introduced into the criminal justice system. This is when the officer has the discretion to engage an individual in the community that they serve, in their jurisdictions. And that's also very important when you talk about what are their powers and their authorities. They get all of their authorities from state statute. We don't get to make it up here in Charlottesville. I don't get to make it up in my rules and regulations as to what their authority is. All of that is governed under state statute, and then they have to go through the current DCJS system, and that's our reviewing system to say these are the powers and authorities, the training that you must get. I can add additional training to it, but all of those mandates on how we engage each other come from that authority that's granted to us by the state. It's important to talk about how we can encounter an individual. We have what we call a consensual encounter. Sometimes you'll hear the words a mere encounter and a casual encounter, but they have to be consensual. Those are the times when the officer can come up to you and you have the right to say, I don't want to engage with you. There's nothing the officer can do. To make it even clear, we publish these encounter definitions on our websites, so that people are more informed about what some of their rights are. A consensual encounter typically arises when an officer approaches them and it's an inquiry about public safety. It can also be a very casual one. If I went up to any of you and said, hey, how are you doing today? Do you want to talk to me? And you decided you didn't want to do that, you would just have the authority to walk away. And there would be nothing that no authority or powers that I or any police officer could have under those circumstances and conditions. The second time is when they would have to have reasonable suspicion in order to encounter you. Now, that's a little bit more in depth. Again, these are all the things that we post on our website so that we have a more informed community as well. When the officer must have certain conditions under which they can detain you or hold you longer, and often it is against your will. When we say, you know what, at this point in time, you can't leave us, but we have to be doing some things, right? We just can't hold you there indefinitely. There has to be some process we're doing, either to get further information, further clarification, and I'm sure these two fine persons will tell you how long we can do that. There have been court rulings on that, depending on the situation, how long we can do that. And also, too, when we can actually physically put our hands on you. There's a lot of confusion about when an officer can and can't do that. And we have not done the proper job of educating the public as to do that. So we keep all of these things on our website as well. When we have that reasonable suspicion, there are things that we can do to determine if we believe that you have a weapon. It can't be just generic where officers say, hey, I think they've got a weapon on them, and then I'm going to do these pat downs. The Terry v. Ohio has been vetted in so many different ways. It is one of the standard doctrines by which the police officers, the Commonwealth's attorneys, as well as our public defenders will hold officers to that standard and very closely. So there's a lot of training that the officers go through before they can even introduce someone into the criminal justice system, because they better be clearly articulating, highly trained. We don't pass the bar, but sometimes I think officers probably should look at the bar, because they do need to know that type of language and where their power and authority comes from. And as I said again, we also have to be very clear about that. the one that most of you will hear a lot is probable cause, right? Oftentimes you'll hear, what is your probable cause? Because we've seen it all over television. You must have probable cause to do these things. You can't do this. And if you're going to stop me, I want my call. I want my attorney, right? I'm entitled to a phone call. I'm entitled to my attorney. We just don't do a really good job of talking about when those facts and circumstances exist. And we don't even do a good job as police personnel and officers and law enforcement professionals when we're engaging an individual who we may be interfacing with, who is being subjected or held, or as we do any of these different steps. Part of those circumstances and facts, we should, as we are now moving towards making sure we talk to people so they understand where they even are in the process, right? We need to have an informed community, but not everyone has access to the information. So what is our responsibility as policing professionals before we introduce someone into the criminal justice system to do exactly that, to inform our communities? I talk about leadership, and the reason I threw this in here is because it takes leaders, and those leaders are not necessarily formal leaders, they're your influencers, to change the systems. And how do you change systems, and how do you get your personnel to police as the first introduction in the criminal justice system so that everyone is fully informed about what is about to happen to them? This group here that I work with does have that large-scale vision about how we police, how we engage the community. And it takes them willing to leverage their personal power to move that vision forward. So what does that look like in terms of policing? Our job is reframing that societal view of policing. How do we reframe that societal view of policing in a way that makes sense in this community, that's tailored to this community? That requires, how do we disrupt the school to prison pipeline? That is, the school resource officers that are in there, we have very intentional conversations about what their roles and responsibilities are. When it comes to them, they are not part of the discipline system. They are not part of the code of conduct system. They are there to protect the students, that are there to protect them from any harms that may come externally or internally, and only when a crime has been committed are they part of that process, making sure that we constantly reframe that. The thin blue line has to be either reframed or completely deconstructed. And what I mean by that is this. The thin blue line should be a line, if you reframe it as a line of comfort, that there is to protect those persons that we are supposed to serve. It also means that we dismantle it, that when there are persons in our systems who are not living up to the values, their sworn oaths, that they are removed from the systems. That when we use and hear the word stop and frisk, that we are very intentional about the way that we restore that. The shooting of unarmed black and brown men in this community, that the policing profession needs to own when that occurs, and they should be the first ones often after they do the same type of investigations that we do when there's any other homicide. What does that look like when we do those same type of investigations for our teams? What does the overcharging, under and over policing look like in those communities? Here's how we're attempting to move that forward in the Charlottesville community, particularly with our police officers. Transparency, legitimacy, accountability, procedural and restorative justice, and intentional, thoughtful engagement. I use those words a lot with our officers about how are we accountable. What is are those intentional, thoughtful ways in which we are moving forward in the community? One, when we think about the deindustrialization of our communities and the governmental destabilization in support of those communities, often that falls back on the policing entities. Unfortunately, what has happened, though, when you are destabilized or when you have institutional inequities, it's often built on a racist structure, a racist system. And when there is historical racism in your policies and practices, you have to look at them and make sure that that does not put a greater burden on police to do things in terms of addressing those societal and social ills that they are not equipped to do, nor would you want them to do. Those are the areas where you start to put the pressure. How do we do it here, and how are we moving forward to meet all of those? We are very public as part of our collaborations about how we interact with Jade. As everyone knows, part of the community here as an introduction of persons into the law enforcement or the drug courts, there is a lot of distrust around Jade. And as a result of that, in our conversations with the Commonwealth's attorney, we have no one who sits on Jade as we currently sit. There are no officers assigned to Jade, and we do not currently have an MOU with Jade. That has not been signed by myself or anyone in our community. When we also look at it is all open data. There was a desire for open data, and we've posted that on all of our websites. We now have crime mapping on our websites so that when we say this is the reason things are going on, we have interactive crime mapping. You can search the map by charges, by day, by week, and those are all posted. You can do all of those things. Our investigative detentions with all of those exact same definitions are posted every month, and I've been doing those now for the last 14 months, I believe. It may be a little bit longer. That has all of that data. When an officer stops an individual, what does the race of the officer look like? The person they stopped, was it an investigative detention? Was there reasonable suspicion? What was the law enforcement outcome from each of those encounters? Our internal affairs cases are posted on our website. I believe we now have 17, 18, and 19 cases with all of the outcomes, including when they were entered into the system, when the complaint was closed out, etc., so that when you say the officers are not serving you, can you see those outcomes posted there as well? We've created internal affairs audit and compliance teams. All of our use of force, because when an officer uses force, they should be held to the highest standards accountable. So we put out a summary of all of those. Every one of the use of force have been on there since 18 and 19 that we have posted for the last 2 years. Our Fourth Amendment analysts, we are in the second stage of interviewing. I will not give an evil eye to anyone over there. She will tell you how she jacked our person that we were offering the job to, but I'm comforted by the fact that we both thought that this person was so qualified, we were interested in them, and so was the Public Defender's Office. So again, even when we were doing those interviews, inviting the Public Defender's Office in to ask us to look at this. Is this the type of person that we would want looking at all of our charging investigative entities? Every policy we have is online. You can look at it, you can search it. All of those things will help us as we are starting to reintroduce, or at least start to really embrace the philosophies of policing. When I leave you with this, and I know I'm at my time, thank you so much. You're supposed to put up a 2-minute or something. What I will leave you with is this. Knowing that we are the first introduction into the criminal justice system, I believe we have the highest responsibility to make sure that we do it and we do it right and that we get it correct, so that when they are being charged by the Commonwealth's attorneys, when they are being defended by the Public Defender's Office, when there is an introduction to the criminal justice system or the process, we do no more harm than we are required to do, or that level that may occur. So thank you very much for your time, for your attention. I can't wait to hear from our other two esteemed panelists. Thank you.
Chief Brackney made a reference to Jade, and I think that may be pretty well known to some of the people in the audience, but others may not. And that's Jefferson Area Drug Enforcement. So it's a task force or a multi-jurisdictional police effort to enforce drug laws. So I just thought I'd add that for clarity.
Thank you.
So good evening. Thanks for having me here. As Jim pointed out, I've worked with him for a long time, but I've been a public defender for over 30 years. I just said over. I didn't do what you did, right? And I have been in private practice as well. I have to say that I like being a public defender. I like being able to represent people and have individual clients. After someone goes through the arrest process and they end up having a warrant issued through the magistrate, the case ends up getting set for usually a first appearance, which involves advisement of the right to counsel, and the court has to advise the individual the charges that have been placed against them. And it's at that moment is when, if somebody doesn't have the money to hire an attorney, that the Office of the Public Defender will be appointed. They also have a right to hire an attorney if they want to do that. They have the means to do that. Because your Sixth Amendment right to counsel really does attach at the very time that the person is placed under arrest. And that's where your Miranda rights that you could probably say that out loud for us, but those rights attach at the time of arrest. So when you end up going into court and the judge is making a decision of whether or not to hold you on bail, you have a right to have counsel also assist you in that process. We have in the public defender's office here, as Jim said, we're in Charlottesville and Albemarle County. There's 7 full-time lawyers and 1 part-time attorney. And covering 2 jurisdictions, we get stretched pretty thin. We average probably about 125, 135 cases for each attorney, well, not the part-time attorney, but the full-time attorneys. And that's not weighted. I mean, it just depends because some cases require a lot more time and effort that goes into those cases over longer periods of time. The more serious charges, but every case is important and everybody's day in court is important. So we try to make sure that we do a good job for everyone. Once the case gets in our office, we have a system set up there where the individual is told when they're in court to come by the office. If they're out on bond, they can do that. If they're incarcerated, then we'll go visit them at the jail, and we try to do that the same day or certainly within 48 hours of getting the appointment. Because that's a really critical time for people, that when you have had your freedom taken from you, and that affects you, of course, individually, but it affects your family. You know, it affects who's going to take your children off the bus that day or put them on the bus. I mean, it affects our community. So it's important to us to try to advocate to get people out back in the community as quickly as we can. Now, there's lots of guidelines on how all of that works, and you'll probably talk about bond, I guess, too, and bail. But
I will not.
You will not? Okay. So we're lucky in Charleston.
Maybe I will.
Okay. We have there's different options that the court has to use. I mean, a magistrate can release somebody then the day that they're arrested and order them to come to court for their advisement of the right to counsel. If they're held, then the court will set a bail for them if they meet certain standards. But it's really tricky sometimes because there could be something in someone's criminal history, or there could be that they lack housing, that they maybe have some mental illness, that it's just problematic for the court to release them. It's our job then to find out how we can get someone out of jail, how we can get somebody back before the court with a plan in place. And that's one of the things that we do, I think, pretty well, and we get in touch with the prosecutor's office. We can get a bond hearing set up generally within 24 hours or the next day that the court is sitting. And let me just back up a minute. Children are arrested and charged with crimes. I've been a juvenile public defender for most of my career, and I think it's really significant how we treat children as they go through this criminal justice process. Kids, when they get locked up, I mean, it's bad enough for an adult to get locked up, but it's absolutely horrible, and it's really detrimental to a child to get locked up. So we go over to the detention center and try to talk to kids and find out what has happened, what's going on with their family situation, and can we get a detention hearing promptly. Now, an adult, you don't have the right to have counsel present at that initial phase of the initial review of bond and appointment of counsel. Children do. We have a law in Virginia that presumes that every child who gets arrested is indigent, that they can't afford counsel, and the public defender appears at those initial detention hearings. And I may not have met that child, but I will be their lawyer because they're entitled to have counsel present. And we try to coordinate with family members at our local court service unit to find out what's going on with the child. Are they in school? Do they have a job? What are the things that are going to help them as they go through this process? And aren't these good reasons to get them out of detention? So that's what we try to do. And that's very different. And it wasn't always that way. That's something that has happened more recently. Part of what we do also is to initiate contact with people's families and their support people, because families look very different, but whoever is the support person for our clients. Because part of the problem that we find is that if you don't look at the whole person and what's going on in their lives, the chances are they may end up getting in trouble or having have to go back to jail if they get back on bond and have a problem. So setting up a plan for a bail hearing is really very important to do. We also, we start right from the beginning. We meet the client, we try to figure out what's going on with the case. We have some discovery not much in Virginia, but in this community, and I think we're going to talk about discovery, maybe. Jim will talk about that. But both prosecutors' offices in this community have what they call an open file policy. So I can go to Joe's office or Jim's office, I can look at the file that they have against my client, all the police reports. So I can read the reports that the police officers do. I can go and ask questions about it. I can call police officers if I want to, and I can investigate that. Other areas in Virginia don't do that. You are not entitled to all of that information. You're not entitled to look at a police report. So we're really fortunate. I'd like more, and I'm hoping there'll be more coming, but that's something that trial by ambush is what they've called it in the past, is when defense attorneys would go to trial and they wouldn't know what the evidence was against their client. And that led to a lot of wrongful convictions. So it's something that everybody up here wants to avoid and doesn't want that to have happen. As a matter of fact, I've had occasion where I've gone to Joe and said, I need this. Will you go find this for me? And he gets on the phone with the police department. They get the information I'm looking for, and they give it to me. So there's a way to get some information if you need it, and there's a way to behave about it once you get it. So that's been extremely helpful. But that's part of developing relationships and working with people over time. Also, as a public defender, when we start getting, we look at the files, we look at, like in the city, I'm really grateful the city has body-worn cameras for officers to wear. And dash cams on the police cars. The county has dash cams, but they don't have the body-worn cameras. That is so important and protects everybody. I mean, if the camera is on, it protects the police officer, it protects the citizens, it's just so important that I'm just really grateful that the city has that, and that's something that we're able to take a look at. Now, the officers are out on a call. They could be out there 3 or 4 hours on a call. I have to go watch that 3 or 4 hours of body camera footage, and I'm obligated to do that. Well, me and the attorneys in my office, because we need to make sure that everything that happened that night with the police was done according to the Constitution, according to the rules and procedures that have been set up at the police department. And if it's not, then it's incumbent upon me to go to the prosecutor and say, hey, there's a problem here. You should take a look at this and tell me what you think. And if I don't get satisfaction from the prosecutor, I'm going to file a motion in the court, ask to have that evidence thrown out because it wasn't gotten properly, the proper procedure wasn't followed, or the Constitution wasn't followed. And then we have to litigate it. So that's a big part of what we do is we file motions. Another thing that's really helpful with the body camera and the dash cams is that it helps even for my clients to go back and look at that. Because if my client was either intoxicated or maybe under the influence of drugs, they had no idea how they behaved that night. And if I can show them the body camera footage or I can show them the dash cam, that's helpful for them. It helps them accept responsibility for their behavior too. And sometimes it leads us to be able to resolve a case that may be favorably for everybody. Let's see. I guess that's what you were talking about a little bit before. I had a note here, the chief talked about that, about filing the motions to suppress. Because it is, the police department take it seriously. I mean, they want to get it right. Everybody wants to get it right, but just sometimes that doesn't happen, and that's why we have to end up going to court and hashing it out there. We also, in our office, we work really hard, as I said before, to try to figure out who our client is and what kinds of challenges that they've had in their lives. So not only do we look at the criminal case that they have against them and the charges and whether they have any defense, but we also look at how can we make things better for them. One of the things that we have a mitigation specialist in our office as well as an investigator and a paralegal. And what that team is able to do is sometimes develop mitigation. And mitigation really just means not to give someone such a harsh punishment. But if they need housing, we can get in touch with someone to help them get housing. If they need a mental health assessment, we can get Region 10 to go out to the jail and see them. We can try to help people who need substance abuse treatment to get them in IOP here in the community so they don't have to be locked up. Sending someone to prison, we have services here at our local jail, but really the Department of Corrections has very little services if anybody gets sent off to DOC. That funding has been cut year after year after year. A while back, I remember when you could take college courses and people would come out with degrees. They'd have skills, they'd get a job as soon as they got out of jail. That doesn't happen anymore. So if you have someone who's been locked up for a long time and then they're trying to come back in the community, it's really hard for them to acclimate getting back here. I've had a client that, a couple of years back, but he came out, he'd never seen a cell phone before. And he looked for a telephone to call his probation officer. But there weren't any telephones hanging up on the wall anywhere. Everybody had a cell phone. So I mean, it's really difficult for people when they're trying to come back in the community. And the world has changed so much that sometimes it's very hard for them to keep up with it. It's also really hard for families when they've lost their family member and then they've been put in the system. So we try very hard to make sure that everybody has a voice, both our clients as well as their family. Sometimes people don't want to come to court to testify, but if they tell us what's going on, we can present that evidence in a way that's favorable to the client. Really, my job is to try to see my client as the whole person, not just the person that's charged with a crime, because that might have happened to them, but that's not who they are. And I need to convince the prosecutor who they are, and maybe convince the judge, the jury about who they are. Because people shouldn't be judged by the very worst day that they've had. But we do that, and we do it over and over again. A couple more things, and I don't know how, I'm not watching time, so I don't know how much I have. But I've got three minutes left. Near and dear to my heart really are dealing with children that are charged with crimes. And one of the things that I find extremely distressing is that what we do in this community is that when children are brought into court, and they can be little kids that have been locked up, because they can be locked up at 10, and I've seen 10-year-old children locked up with chains. They have belly chains on them, they have shackles, and they're brought into the courtroom and they have to stand there. They don't even come up to my shoulder to stand in front of the judge asking for justice. That's just wrong in my view. And it's wrong in my view for adults to be treated that way. And to further indignity for at least male clients of ours at the jail, they wear black and white stripes when they come into court with a belly chain and shackles and handcuffs on. Now, not at a jury trial. They're allowed to wear their clothes, but otherwise they come in that way. And for kids, that really, there have been studies, lots of studies over and over again about how detrimental that is to their development, because they're kids, and many of my adult clients are kids. They may have reached the age of 18, but their brain is still forming. So it's hard, and when it's demeaning to them. So part of my job really is to advocate for that. And I've been fighting to try to get rid of these shackles for years, for as long as I've been a public defender, and I'm hopeful that maybe I'll inspire some of you to jump on board with me on that. Most of the kids that we have that are locked up are coming from Blue Ridge Detention. When the public defender office first started here, we would go to Stanton, the detention center. In some ways, it was better. In my view, it's easier for me to see them here, but they didn't always get sent across the mountain if it was late at night. Somehow, somebody was found. His grandmother, somebody was found to take the child home. So we just have to remember their children. We forget that a lot. Whoops. Yeah, so I've seen 10-year-old children. You could be as young as 10 locked up. But I have not seen a 10-year-old locked up in Charlottesville in chains. So if I said that, that's not what I was meaning.
That was a little bit misleading.
Right. No. I just meant at 10 years old, children in Virginia can be locked up. If they're locked up, then they're they're subject to these other things. Most of the time, kids are not, it's been a long time since I've seen even a 12-year-old locked up in Charlottesville. They're back early on when I first came to Charlottesville, they were, but I haven't seen that in a very long time. So that has changed. And that policy, your office's policy, has really changed that about whether or not younger children should be locked up. Yes, sorry.
So I'd like to thank Meredith and the Road Forward PAC. Thank you, Jim, for moderating, and thank you to Chief Brackney and Liz. So I was trying to think about what I wanted to take my time to talk about related to understanding government and the role of the prosecutor, and I really appreciated what Chief Brackney was saying when she was talking about how to reframe some of the legitimate problems we confront nationally and certainly locally. And how do we reframe things as prosecutors? And I guess my answer that I was thinking through when she said that is, I think we do it one case at a time, one interaction at a time, one situation at a time. And we've got work to do. There's areas we need to improve, and we don't always get it right, but I think that reframing happens with intentionality, and it happens, sort of case by case, and you just have to sort of keep marching. So what I want to talk about, and maybe I can catch us up a little bit, I don't think I need 20 minutes for it, but I have 3 points related to my discussion about the role of the prosecutor in the system, and the 3 points are as follows. Point number 1, the power of the prosecutor. Point number 2, collaboration. And point number 3, community safety coupled with a fair treatment of offenders. I'm a big fan of trilogies. I think trial lawyers sort of, like Winston Churchill, we came, we saw, we conquered. That's Vine Vidi Vici. By land, by air, by sea. So I'm a believer in trilogies. So my trilogy for tonight for y'all is the power of the prosecutor, collaboration, and community safety coupled with the fair treatment of offenders. And I want to talk about those 3 points by telling you about a case I had, and it's a case I had with Liz Murtagh. And it touches on some of Chief Brackney's points. So as a prosecutor, we get a file, and it's put on our desk. And one of my colleagues in the U.S. Attorney's Office is here in the audience, and sort of they have boxes. And in the state system, we get a file with a few pieces of paper in it. And so we don't have all this voluminous reports and discovery and interviews. We sort of have to sometimes build it from the ground up. And that's no knock on the police. We just sometimes, in the state system, we get what walks through the door. And it's not a lot of pre-investigation charging decisions in cases. So it's, 1 or 2 in the morning in a densely populated Charlottesville neighborhood. We're 10 square miles, so it's not like we got a lot of country where things can happen. And some gentleman's had a couple too many drinks and gets his hand on a firearm and fires off 1 or 2 rounds. And the neighbors are concerned about gunshots at 1 or 2 in the morning, so they call the police. So this would be a non-officer initiated response. So the Charlottesville Police Department get a call, and a neighbor's like, someone's firing a gun off. It's 2 in the morning. Can you send someone to come look at it? So the Charlottesville Police Department responds, an officer responds, and they find, I'm calling him an older gentleman, mid to late 40s, which I guess I am. I'm 48, so.
So he's a youngster.
He was not a 10-year-old, Liz. He had some maturity about him. So he's mid to late 40s, and he's super intoxicated. And the officer comes up to him, and he's like, "Sir, we've just had a report of shots fired in this exact area. Do you know anything about it?" And he's like, "Yep, that would be me. And there's the gun over there on the wall that I fired off in the air a couple times, and I am drunk." And the patrol officer's like, "Okay, well, let's get some information here, and can I have your name, sir?" And they have, an interaction. The gentleman provides his name, and the officer does what's standard in that situation. He's got a guy who's just shot a gun off in the middle of, a neighborhood. The citizens have called complaining. The gentleman's intoxicated. So he gets the gentleman's name, and he ends up finding out over dispatch that the gentleman has a prior felony conviction. And when you have a prior felony conviction in the Commonwealth of Virginia, unless you have your rights restored to possess a firearm, it's a crime, and you cannot have a gun. So the officer's like, "Okay, give me some more information on the felony," and it's a breaking and entering felony, which means at some point he broke into a structure or dwelling when he shouldn't have. Now, that doesn't sound like the worst case in the world. It's not rape, robbery, murder, malicious wounding. But in Virginia, a breaking and entering is considered a violent felony. So when you possess a firearm and you have a prior violent felony on your record, it's a mandatory 5-year prison sentence. Woo! Yes, I got a lot of woos. That's what I said, too.
That's what I said.
To make matters worse, the breaking and entering was about 20 years old. This guy was like in his early 20s when he was convicted of the violent felony breaking and entering. So the police officer does what they have to do. There's no discretion there. The officer's like, well, you're a violent felon. You have a gun that you confessed to shooting off. I've got the gun. And you have a violent felony on your record. So I have no choice. There's no discretion here. I can't let you go. So he arrests him appropriately, takes him to the magistrate, and the magistrate issues a warrant for violent felon in possession of a firearm. So this gentleman, I am not trying to sound arrogant, but that's a pretty good case. Like, I think I have a pretty good chance to get conviction there, like a full confession, the gun. It's sort of like there's no way to lose that case as a prosecutor. So it comes to my desk, and I'm sort of looking through the reports and, not really paying a lot of attention to it, but I see it's a violent felon with a gun. I look through some facts and sort of set it aside, and I know that he'll have a preliminary hearing coming up in about a month. And he's in jail because it's a violent felon and it's a presumption of no bond. So power of the prosecutor, collaboration, community safety coupled with the fair treatment of offenders. So my phone rings, and it's my good friend Liz Murtagh. And she said, hey, I just got this case. Like a day or two ago, this gentleman was arrested, and she lays out everything. And she said, so it sounds bad, but I went to visit this gentleman at the jail, and I got to give you some information. Correct me if I'm wrong, but I think he was working with kids in the community, and he had like a recording studio in his basement and was doing a lot of really good community outreach. And she's like, so Joe, my first problem is this guy's sitting in jail. It's not as bad as it looks. It's 20 years old. It's a breaking and entering. Can we get him out? And so there's no judges here, but it's true that the judge is the one that releases him or not. But little secret, if the prosecutor and the defense attorney go in front of a judge and say, hey, we want this guy out and here's why, the guy's getting out. Like, that's sort of how this works. So Liz makes her pitch, and she's like, look, I got a place for him to live. He can go back there. And Liz is a great defense attorney, and she's a fierce advocate, but she does something very smart. She's like, look, he's guilty. Like, I'm not trying to sort of create some defense, but let's first just take the first step of get him out, get him back to his family, get him back reintegrated with the community. He's got a job. He's got stability. Let's get him out of jail. So she said, let's just do that first. I said, sounds reasonable. I trust Liz. It's a good plan. We schedule it as soon as possible, have a bond hearing, explain everything to the judge. He's presumed innocent. We're not saying anything about, we're proceeding right to sentencing. But our first stage is a prosecutor and defense attorney. This is point 2, collaboration. And point 1, the power of the prosecutor. Judge, we'd like to get him out. Here's the plan. We don't use cash bail in the city of Charlottesville. So we'll just have him sign his own bond. He doesn't have to put any money up. Put him out, get him out. We got a court date 2 months down the road. Good. So we get him out. So that's the first step that we take. I also had talked to the patrol officer that had arrested him and made the case and said, look, is there anything I should know about? No, he was actually very polite. He was cooperative. I kind of felt bad that I arrested him, but I had to. I didn't have a choice. So the patrol officer was responsible, and there was no information the patrol officer had related to why we should try and keep him in. Like, he actually is responsible for 5 other shootings, and so we got to be real careful about this. That was not the case. And then collaboration. Victim witness reached out to the neighbors in the neighborhood and sort of apprised them of what was going on, and we had buy-in from the community when we gave them a little bit more information that we weren't turning some maniac loose that was firing a gun and might, a bullet might pierce a wall and kill somebody. So everyone's on board with the collaborative part, police department, public defender, victim witness. So we get him out. So Liz's next phone call to me is, okay, why does he need to go to prison for 5 years? And I was like, well, that's a very good question. I don't think he does. And she's like, well, you got him charged, Joe, and now it's not in the police officer's hand. Now it's in the power of the prosecutor's hands. She said, well, why does he need to go to prison for 5 years? Can you get rid of that mandatory time? And I said, sure, that sounds reasonable. And I tell this story, and I've told it repeatedly, and people, their heads explode. So the way to get rid of a mandatory 5-year prison sentence on that charge is for me to go in front of a judge with Liz and take a pen and say, hey, judge, can you just cross out and we'll initial violent felon and just make it felon in possession of a firearm? And the judge is like, sure, motion to amend granted. The 5-year mandatory evaporates when you get rid of that violent felon language. It's still illegal to possess a firearm as a convicted felon, but now Liz has got a fighting chance to convince a judge that he doesn't need 5 years in prison because we've removed that mandatory sentence from what a judge has to do. So now Liz is feeling good. She's like, all right, I'm making progress. My client's out. He's adjusting well. He's doing good. He's working back with the kids. He's got a stable residence. I just got rid of a 5-year mandatory prison sentence on a pretty much slam dunk case. So things are going well. So we're getting ready for a guilty plea on the felony in circuit court. And she's like, I think I can convince the judge for not a lot more jail time or maybe probation. So we keep talking. And I don't remember who said it. I'll take credit for it, but it was probably you. But I said, hey, Liz, I said, why does he even need a felony conviction? Or maybe she said it. But I'll take credit for it. And I think Liz was like, Joe, you have always been so smart and sharp, and that's a great idea. Why does he need a felony conviction? So what we come up with is a written plea agreement to present to the judge, and her client comes into court, and she says, I really trust that this guy's going to do well and not reoffend. He's doing a good job. So she said, how about we plead him guilty to a felony, but we continue it down the road for about a year, and we'll come back to court, and if he's done as well as I know he's going to do, and she's gotten to know him at this point, why don't we see if he can have a misdemeanor reckless discharge of a firearm? You can't shoot a gun off at 2 a.m. in the middle of the city drunk. You can't do that. Like Chief said, there's certain things that are crimes that have to be enforced. But sounds good. We explained to the judge what we wanted to do, why we wanted to do it. The gentleman came in, entered a guilty plea to a felony with no mandatory time, and we said, we'll see you in a year. Come back and tell us how you're doing, and if you're doing well, you get a misdemeanor reckless discharge and a suspended jail sentence. And he's already a felon, but we're not going to give him another felony. So that's what we did. Mm-hmm. And just recently, we had our 1-year review. The gentleman was doing really well. He ended up being convicted of a misdemeanor reckless discharge. He did not receive any more jail time than the couple of days he had spent in. And that concluded the case. So again, the power of the prosecutor played a role in that. Collaboration with the police department and the public defender's office and victim witness and the neighbors, the patrol officer. And we also, a guiding principle in our office, which we try and base everything we do on, is community safety coupled with the fair treatment of offenders. I think we kept the community safe. It was under advisement. He was monitored, and he was treated fairly. Do we always get it right? Do we have things that we do incorrectly and there's no room to improve? I'm not saying that at all. But I like that case, and I think that people need to understand how when you get well-intentioned people working together and on the same page, that you really can do some pretty remarkable things. And I think that's the challenge that we want to present to ourselves in this community. And I think everyone sort of talked about that a little bit. So that's sort of my spiel on the three things that relate to the role of the prosecutor. And we can't do it by ourselves. We really depend on our partners, the public defender's office, with the judges, and the police department. So, Jim, I know I was less than 20 minutes.
Great.
19 minutes.
Thank you, Joe. I think you might have saved 3 minutes because you're very big on trilogies. I think, and so I'm not Winston Churchill, but I'm going to start off with a trilogy too. How about that? I'm going to have a question for each of the panelists to kick off our discussion. So the first question will be for Chief Brackney.
Oh, yay!
And so everybody's familiar, I suppose, with the legislature's action recently, very recently. They just adjourned, but they decriminalized marijuana possession. And I think people are pretty familiar with the term of decriminalization versus legalization. So decriminalization means that possession of marijuana is still illegal, but it's not punished as a criminal offense. It's punished with a civil fine. And a lot of people see decriminalization as a step toward legalization. So I don't know if that's coming. There were some legalization bills in the legislature this time around, and they were put off for future consideration. So this time we did get decriminalization. So Mark Herring, who's the Attorney General, was an advocate for decriminalization, and I have an article here that in which he talks about that, and I'm going to quote a little bit from the article and then ask the question. So Attorney General Mark Herring's view is that the human and social costs of marijuana prosecution are enormous, in addition to the millions of dollars it costs Virginia taxpayers. And the negative consequences of the current approach, this is before decriminalization, fall disproportionately on African Americans and people of color. And then he cites a statistic that from 2007 to 2016, African Americans were 46% of all first offense possession arrests in the state, and at that time they were 20% of the Virginia population. So one of the arguments for decriminalization is, according to the Attorney General, the disproportionality in terms of enforcement of the marijuana laws. So my question for Chief Brackney is, now that marijuana has been decriminalized, and that means that it's still it's still an offense. It's still something that the police will enforce. The penalties are not as severe as the criminal penalties. Now it's a civil penalty, a fine. But law enforcement still has the responsibility for enforcement of the marijuana laws. And thinking back, Chief Brackney, to what you said about all the various functions that the police have, and you stated in your presentation that a lot of them are social services interventions. Do you see the decriminalization of marijuana as an opportunity for the police to reduce the number of enforcement resources going toward marijuana and put them more toward other policing activities? And just generally, how do you see this bill as affecting the work of the police, and particularly as it affects race in our community?
So thanks for that. That's actually a softball, because Joe and I sat on a panel about 6 months ago, in which we were both advocates of this, very public advocates of it, not just being decriminalized but legalized, but understanding there are also some concerns and issues, whereas who benefits when you even legalize it, right? It's typically not the person who you think is going to benefit, or we haven't thought that far ahead. And we also looked at our statistics. It is not a priority, and I think we looked at the last 2 years, and there were less than 5 possession charges for marijuana from the Charlottesville Police Department. So this was already an issue that we weren't addressing anyway. It wasn't a priority for either of us in terms of what we believed where there needed to be a charge. So in terms of us diverting resources, we don't have to, because it wasn't something we were embracing as a philosophy anyway. So that was part of mine. Also, too, I think when we talk about decriminalizing and what that looks like across, there are a lot of policies that we believe that we can look at legislatively that can help with the making entree into those communities that have been disproportionately affected by laws, and then how those laws not only have been created, but the implementation of laws. It's not enough of how they're created, it's how they're enforced that can increase disproportionality along it. So I'm also not familiar with each of the individual studies. Typically when we say, oh, there's a possession, is there some other possession that went along with it? Was that the only single charge, right? Which would then say something very intentional about how policing has occurred across the Commonwealth of Virginia, and not necessarily reflective in Charlottesville. Joe, if you wanted to build on that.
Yeah, I'm not sure the number was 5. I forgot what it was. I think
it was 5 in the last year.
I don't remember. I do know that when we were on the panel, we're saying that it's not a priority for the Charlottesville Police Department. It's not a priority for our office. But if someone's arrested for DUI and they're, handcuffed and taken to the jail and they've got some marijuana in their pocket, I think that you have to look, are they out enforcing the marijuana laws, or is it related to something in their possession related to other sort of conduct? But
Liz, you talked about the humanity of your clients, and you talked about dignity. There's recently been some public defenders in Pennsylvania who were fired because they talked about things that happened to their clients. And I want to ask you a question about that. I'll quote from this article just recently this week, talking about criminal justice reform. The debate around criminal justice reform often operates in abstractions based on data, studies, and broader crime trends. This sort of analysis is an important part of the conversation, but without personal stories that defenders witness on a daily basis, the system is blind to the humanity before it. And I want to thank you for helping open our eyes to the humanity of the people who come into the criminal justice system. But can you expand on that a little bit? Experiences that you've had or situations that you've seen that might be helpful for this audience to know about.
So probably most of my clients have, there's multiple layers. Well, we all have that in our life, have multiple layers of things that go right and things that go wrong. But I find with my clients, it seems like over and over again they've had something that has gone wrong, and they take 2 steps forward and they take 1 step back. So they may make progress, but it's a really slow process for them. That part of what to me is really important is to be able to tell their story, and particularly with people who have struggled with addiction and with mental health problems. That on the face, as you were talking about, that so many people, that's a lot of your calls, are folks with mental illness, but they may appear as very violent and aggressive, but it's maybe because they haven't had the money to buy their medication and they're not on medication. So that's what I see, and just seeing the human being that's sitting there, it's just so important.
Again, we do hear a lot about criminal justice reform. It's something that is very much in the public eye right now, and this session of the legislature has been working on some criminal justice reform issues. I'll talk about a few of those in a moment. But in your presentation, you talked about, I think, if I put a term on it, criminal justice reform one case at a time. And I think that type of criminal justice reform relates to what you talked about with the power of the prosecutor. And sometimes that power is described as prosecutorial discretion. But that's how a prosecutor can bring about criminal justice reform one case at a time. And so your story talked about one issue that could be done either legislatively or by a prosecutor using discretion, and that's mandatory sentences. So we can have the end to mandatory sentences by having legislation that eliminates mandatory sentences. Or we can have prosecutors, in the absence of that kind of legislation, do it one case at a time, as you did. So what I'd ask you to talk about is other things that you look at as carefully as you looked at that mandatory sentence that are movement in the direction of criminal justice reform. What other factors do you look at when you use that prosecutorial discretion to bring about a fair outcome, even though the law, as you said in that case, provides for a conviction that you and the defense lawyer and ultimately the court may feel is not the right disposition in the case?
Well, it's a very good question, but it's a very nuanced, complex question, and I don't like speaking in generalities, but I really do go back to and try and have everyone in the office go back to community safety coupled with the fair treatment of offenders. And we are prosecutors. We are supposed to enforce the laws and prosecute people. So we always have to think about community safety. But the flip side of that coin is some of what Liz was talking about is when you prosecute someone and convict them or seek a conviction for a felony or even a misdemeanor, and then you have with it probation or incarceration or community service or any of the different consequences for their conduct should they be convicted, you are disrupting their lives and the lives of their family members and loved ones. And so I think to answer your question in a very general way, I think if you look at each case and are guided by community safety coupled with the fair treatment of the offenders, there's so many different areas of gray that you can look at to sort of divert cases or put them into treatment court, or there's just a bunch of different options that you have and a bunch of different tools in the toolbox. And I think that, you if you sort of turn it into just stamping stuff and just doing what you do because you can, you run into trouble. So,
all right, let me follow up on that. One thing that I know that you consider a lot is whether somebody should be convicted of a felony. Now, they can be convicted of a felony if the evidence is there, and oftentimes it is. But is it the right thing to do to convict somebody of a felony? Because we know what the consequences are of that. In addition to losing your voting rights, there are all sorts of other negative consequences that come from felonies. So our office looks very carefully at somebody who's charged with a felony, and it would be their first felony, and I'm sure that the city prosecutor's office does as well. So that's one of those things that you can do one case at a time, just like you can strike out the language that requires a mandatory sentence. You can strike out the language that requires a felony. You can hold somebody accountable that can be reduced to a misdemeanor. So I'm going to give a brief review of some criminal justice reform legislation, and then we'll throw it up into questions. And on this issue of felonies, this year the legislature, House Bill 995, increased the larceny threshold, and by threshold I mean the difference between misdemeanor larceny or theft and felony, from $500 to $1,000. So there's a legislative solution, at least, to felony prosecution for people who are charged with stealing something now that is in the range of from $500 to $1,000. They would be guilty of a felony. Now, because of this legislative change, they would not be able to be prosecuted for a felony but only a misdemeanor. So that's a kind of example of how legislation can also bring about criminal justice reform. We've had a number of proposals to change jury sentencing in Virginia, and jury sentencing is a very important part of the system. Most of these have been carried over for further study, but the bills, one bill has given defendants a choice whether they want to be sentenced by a jury or not, and that's a very big decision. Another bill on sentencing is the legislature had a bill which was continued, it hasn't been passed, but a bill allowing the jury to suspend a sentence. And that's a new concept. Right now, the jury gives a sentence and they don't have too many tools the way a judge does. The judge has the tools to suspend a sentence or run it concurrent or make a referral for community services, all sorts of things, but the jury is just sort of binary. If you're convicted, you get a jail sentence, and it's you don't have any tools to change that and suspend it. But they offered legislation this year to give juries that power. That's under consideration. And the last thing that they did pass with respect to sentencing is they're allowing juries to be asked questions about whether they can be fair in consideration of the case in view of the punishment. Up till now, you're not allowed to ask jurors about the punishment, only about matters affecting their ability to give a fair hearing in the matter of guilt or innocence. And this is really important because juries take, for example, the mandatory sentence that Joe talked about. A jury can convict somebody of an offense without knowing that if they convict them, it's going to be a 5-year mandatory sentence. So this is a way of giving more transparency, opening the jury process up and giving the jury more information. One other very important legislation that did pass is a procedure for allowing indigent defendants to ask the court for expert assistance. and do it in an ex parte proceeding. An ex parte proceeding means that they get to ask the court to give them money to help with their defense without telling the prosecutor what's going on, without telling the prosecutor why it is that they need an expert to assist them in their defense. Now, when you think about it, this is for indigent defendants. If you have money, you can hire any expert you want, and you can consult with that expert, and if the expert comes back with something that's not helpful to your case, then you say, well, too bad, we tried. But the prosecutor doesn't know about it. But if you have to go as an indigent person to the judge and ask for money and do it with the prosecutor listening in on why you have this need for money, it changes things dramatically. So I'm delighted that the legislature has passed that legislation. And Ron Huber's here, who's an assistant U.S. attorney, and Ron knows that in the federal system they've had this law allowing ex parte applications for expert assistance in the federal system for as long as I know, a long time. Questions? Yes.
Thank you, Chief Brackney, for your wonderful presentation. I have a question for you. I had a two-part question for you and for the panel. First of all, the Civilian Review Board. What's your take on it and why? You like it or you dislike it? Secondly, the question is for the whole panel. The city has paid a company to do a disproportionate minority contact in the criminal justice system, in the adult criminal justice system. What do you think about it, and what your opinions on it about the next steps?
The DMC study and the CRB were both initiatives that were started prior even to my arrival. So I must make that disclaimer first about how those came about. I'm not really, wasn't part of the initial process, but was introduced into it in June of 2018, or so, actually May, when I first was coming here. When it comes to civilian review oversight, I'm a supporter of legitimate civilian review oversight of all government entities. There should be no entity in which is supported by government that there isn't legitimate oversight of that. So I have no desire or fears when we do the things that are correct. Anybody who is in the public service realm, from any administration, my office, Joe's office, public safety or public defender's office, there should be oversight that we all answer to someone, and however that looks, I am supportive of that. In terms of the DMC studies, I think they've actually said what their next steps were, that they needed to go back in front of council and look at that. And more importantly, my statements have come out in terms of the DMC study saying I was one of the first ones who said that how do you conduct a study where you don't talk about the entry point into DMC or disproportionate minority contacts?
In my brief answer on that, on the DMC, is one of our research people said, well, good research leads to more questions. So I think it gave us a lot of questions and a lot more data that we need to seek and continue to follow up on the important work. But there are problems that we all know exist and we need to address and figure out how to do that. There was some disparity or disproportionality on pretrial release decisions and number of charges lodged against people. And I'm not trying to say the prosecutor's office doesn't have areas we need to look at and fix. I'm not at all. But some of the pretrial release decisions were at the magistrate level before they got a defense attorney and a prosecutor in front of a judge. So we got to look at where in the system are African-American folks being...
Those two systems didn't get...
Correct. And so, correct. And then number of charges, is that is a prosecutor indicting someone with 50 felonies, or is a magistrate issuing those? You're exactly right. So we got a lot more work to do and a lot more digging. It was sort of a first step, but problems.
I'm Edith Good, and I go to Housing Authority Redevelopment Committee meetings, and this is about the decriminalization of marijuana, and we are bulking up a Section 3 application process so that residents of public housing can get training for work that is going to be done with redevelopment. This is open to other areas too, but public housing residents have priority. But anyway, and the question is, an awful lot of people smoke weed, and is there any way that if you're applying for a job, I don't exactly know what my question is, but
maybe it is, will you get in trouble if you get caught smoking weed?
Yeah,
and can't get
or
your
would
job?
you pay a fine, and then keep on working, or no? I guess not. But
so I think it.
And then we can move on. So,
okay.
Since you're not, it's a little bit confusing. But yes, the legislation that's been passed also has in it some restrictions on what employers can ask for in terms of your past conduct. So, I think this is a legislative fix that's coming. And addresses, I believe, what your concern is. So yes, it's going to improve. Next question, please.
What we also need to think about as a team, and I know Joe and I have talked about it, is what does that look like to disrupt even in advance? So even though it's been decriminalized, what does that look like to even divert before someone is introduced into the criminal justice system, even with a fine? Because fines can be, $25, there are a lot of people that don't have $25, and that's a lot of money, and you take away from it. I know as often as I Zelle my daughter $25, that, as a college student, as a person who is in a low-wealth community, how do we even disrupt that in advance so that we're not introducing people and that's not part of their issue to compound it, that they're already in a they're low income, and they're just trying to make it ends meet. So how do we do that better as a community so that we have really a co-production, as I say, of public safety, and not just one person, as Joe and I are being the persons who are in the enforcement area? So thank you for that question.
Okay, so I have a comment and a question. My comment is to Chief Brackney. Thank you for the presentation. One thing that I really didn't see highlighted, which is very prevalent, is the mental illness and how that relates to people coming in contact with law enforcement. They're 16 times more likely to die coming into contact with law enforcement, and that number is even higher when they are African American. And some people say it is a death sentence to call 911 when you're in a mental health crisis and you're African American. And then the second, this is a question to the prosecutors. So in your story or your illustration of one of your cases, you talked about the point of contact, the seriousness of the charge, you talked about the bond and the outcome. And every single one of those is in that report as something that African Americans are, there's a disparity and there's a great disproportion. And so you gave a perfect illustration. And as I look at all of the recommendations, none of them relate to the prosecutor's office, and it seems like you're the one who just gave an illustration of how you have the power to do something about that. They're talking about reentry. That happens after the person has already left jail. And I've looked at all of that report, and none of them seem to address the people, whether it is the judge or the prosecutor or the magistrate, and actually even looking at those numbers disproportionately or holding those people accountable, because you can put all these programs you want into place for social and special interests, but you're the one who has the power in some of these things, as you so perfectly illustrated.
So one of the things that we need to do further are, one of the conclusions of the report is that there was not disparity or disproportionality related to sentences imposed in circuit court, but it also didn't get general district court. But I think you hit a very important point. The mental illness point is extremely important, and maybe Chief Brackney will talk about CIT trained officers. But what you just talked about and what Mr. Foley was referencing is sort of data sets to look at that sort of stuff. We don't have any data that they could access to look at some of that sort of stuff that captures when is a prosecutor doing certain things for certain types of people. And I'm hopeful. When I started the process with the group from Florida, I said, are you going to sort of give us some specifics of what to do next and look at ourselves? And that is, there are several data sets missing in our statewide system, including the prosecutor's office, the magistrates, and there are a couple others. So you are spot on with what you just said. And in order to be accountable, to have someone look at the decisions we're making, we got to figure out how to record some of those decisions about, I didn't tell you the race of the person that we interacted with, and that might be an important thing. It's like, well, are you doing that for white people but not African-American folks? And so we need to work to start figuring out how to capture some of the data that relates to that sort of stuff, which I'm hopeful that the next layers are going to start to give us. And Mr. Fogel, I don't know if he's still here or not, but he has to meet with me and with Mr. Hingeley, with some law students, to go over the report and some ideas that they had. So it's a conversation we need to keep having, because you brought up several excellent points.
And you're exactly right. My first slide has said what we actually really do. The first one was mental health crises, that the majority of the persons that we come into contact with are exactly right. They're experiencing a crisis, right? And our officers the best equipped. And because we now know that when anybody calls us in a crisis, whether it's 24 hours a day, the officers are going to come. If that is going to be the mechanism by which those services are then rendered, our officers have to be the best trained. All of our officers are trained in crisis intervention. They are probably one of the most highly trained. The crisis intervention coordinator for this Virginia region is actually housed in the Charlottesville Police Department as the subject matter expert, and going out and pushing that out into the community. You're exactly right. When you look at statistics, those behaviors, if the officers are not familiar with behaviors, compound that with all the other issues that intentions that are going on between law enforcement and, let's just come straight out and say, the black community, particularly our males, who are extremely vulnerable when they engage law enforcement across the communities. We have to do our best. And we also have to then start holding society accountable, right? When our government dollars are being used for other things besides helping those persons who need those helps and interventions. When we cut monies for state hospitals, and that started back in the 1970s, as far back in Pittsburgh, cutting them for state hospitals that had really good, healthy care and people could go to. They've cut them in the Veterans Administrations under mental health care. We've cut them, and I think even here in this area, Region 10 is receiving less funding. So when you see what we value, we say we don't value people who are in crises.
My name is Cherry Hingeley. I have maybe a comment, a question for you, Joe, and also for you, Ms. Murtagh. And you may have answered, Joe, when you were making the reference about the person that was arrested. I was wondering if, because for African American, when those charges, I work with ex-offenders all day long. This is what I do. When those charges...
Thank you for it.
You're welcome. So when those charges come in, like that one charge came in for an African American I see on a regular basis, that would have been 10 charges. They would have compiled that into 10 charges.
Well, this person was African American.
Well, I'm just saying generally, not all the time, maybe.
Yep.
But do you recognize that from the magistrate office or whoever that could be a problem?
Yes.
Thank you.
And let me tell you why. So you're a drug addict and you steal somebody's checkbook and it's got 10 checks in it. And you're a drug addict. So you forge 10 checks and then you utter the 10 checks to get the money to feed your drug habit. That's 10 forge, 10 utters, 20 felonies. I think it's 10 years on each, 200 years. So in our office, what we try and ask ourselves critically, and I want to stress to everybody here, I'm not saying we always get it right. We don't. We got problems. But to your point, we try and have the conversation before we even speak with defense counsel. Why in the world, or if there are 20 charges, why in the world are there 20 charges? Why do we need that many? Will one suffice? Will one misdemeanor suffice? What was the loss? What did the citizen that owned the checkbook lose? Did their bank reimburse them? So anyways, great question, great point, and absolutely. It's called stacking charges and piling on, and it does nothing to promote community safety. Nothing.
Okay, my answer, you, Ms. Murtagh.
I agree with that, too.
Thank you. But I was wondering if, and Mr. Hingeley, I done brought this to your attention too when you was a public defender person, head of. Are you aware that And I don't know how many attorneys you say you had in the public defender. Did you say 7?
7 full-time, 1 part-time.
Okay, well, that answers a lot right there. But are you aware that those attorneys are not visiting their client at the time, like 48 hours, or it may be 2 weeks, or maybe never? And I can attest to this because I'm an ex-offender, which been a long time ago, and my attorney didn't visit me. And by the time I got to court, I was just hearing, I had to make a decision on a plea bargain within 5 minutes or something. Do I want to take 20 years? Which is a joke. But this is what's happening.
That's horrible.
But I'm asking you, are you aware? Because, as I said, I work with ex-offenders, and I have them call, they write me, or their families contact me, and I call the office all the time to talk to the attorneys to make sure that they are getting in contact with their attorneys, but they are not visiting the inmates.
So two pieces to that. One, there's the public defender office, but there's also, on cases where we aren't appointed, court-appointed counsel is appointed, and that comes from members of the private bar. I have no control over them or what they do. They have to be certified by the Indigent Defense Commission, but they don't work for me. The attorneys in my office, they work for me, and if there's a problem, you need to let me know about it, because my expectation is that they get seen by generally it's our investigator. If they're locked up, the investigator goes out there with. We try to do it the same day we get the paperwork from the court, but that doesn't always happen. But certainly within 48 hours. And if that's not happening, then then let me know, because people can't be in jail without having an opportunity to talk to their attorney. They also. There's witnesses. There's lots of things that need to be done. My biggest pet peeve is that people need to get out. And you can't do that if you don't talk to people.
Hi, my name is Patricia Eldridge, and thank you very much for your presentations. I appreciate your efforts. I brought notes. Okay, I want to relate my firsthand experiences, and I also want to say that I am not alone in this. Illegal sting operations, police violating Department of Justice and police standards. These aren't Department of Justice and police recommendations. These are standards. Police perjuring themselves on the record. This is documented. This is in the record. That doesn't even begin the story of racial profiling. Okay? Nothing has changed. And I want to know why this continues now. What is being done about this? What are you going to do about the lives that have been ruined because of these actions?
I'm guessing you're directing that towards me. I'm just
to Albemarle and Charlottesville, because
Can you provide the source of the documentation of the perjury?
It's in the court records.
Which ones?
Yeah, I have no idea.
This is in Albemarle.
Yeah, so I can't speak for what's going on in Albemarle, but again, what I can say when we talk about criminal justice reform, period, I think there's more things, or it's more complicated and nuanced if I don't know exactly what cases we're talking about, right? But there are very clear rules about what we have to do. If you say there is a documented perjury case, those officers, as Liz will tell you and as Joe will tell you, those officers cannot testify in any court proceedings from this point on. We have to turn over that information, and actually they should be fighting for that to have already been.
Can I say something?
Yeah.
So there's some communities, and certain prosecutors have been sort of lauded for turning over the do not call list, that were these secret lists of police officers that you couldn't call because they had problems in their past related to truthfulness. So I was talking to Chief Brackney, and I was like, well, I don't think we have do not call lists in Charlottesville. If a police officer can't be called to the witness stand to testify, or there's something related to their untruthfulness, long before Chief Brackney, my experience as a prosecutor and public defender is they're let go. Like, I don't have a list to give to Liz of who we can't call as a witness. It doesn't exist. We just don't have it.
One would hope.
Yes, that's right. Yeah. You're exactly right.
Unfortunately, in this room, no one is safe. Okay?
Okay.
Do we have time for one more question? Okay, last question.
Well, I need to ask the question. They say they are locking up children like 10. Is it 10 and up or not here? Now, I know you say Charlottesville is not happening, but I have to keep up with the news, local, and,
the law allows for that.
Yeah, but, okay, if they're locking up children, what is the crime that they're locking the kids up for? Because I read recently, and I know y'all heard about it because I keep up with all news, they went to school and arrested some children. Now, how is that possible? How do you arrest a child from school?
Yeah, that's not happening here.
No, I know you said Charlottesville wasn't happening.
Right.
Don't mean it can't.
But there have been not far from here where.
Well, how?
Yes,
what kind
right.
of crime did the child do? Just act it out?
That was my understanding, that there was
Well,
acting out
you
in
don't arrest
school.
a child for acting out. You call it parents.
There would have to be a criminal charge, of course. But I maybe
Doing what, kicking the teacher?
like I don't know what it was. But in my book, that sounds more like misbehavior, and the child needs to be dealt with in a school setting. But I can't speak to the facts of that because I don't know what they are.
Well, I would hope that if it was my grandchild, call me. I know how to take care of the children. You don't want to call the police. That don't make that's trauma. And then they wonder why children grow up not to trust. You don't do that. Somebody needs to change that policy wherever it happened. I don't remember. And another thing, I heard tonight that I thought marijuana was legal. Not here in Charlottesville. We late all the time. Late. But I want to know, is it still affecting people, their
driver's licenses?
Rights to vote? I thought that you could vote if you had a felony. Is that not right? I thought you was... You can't
Not a felony.
Well, I heard that you can't. It mess with your voting and all.
No, it's not a felony.
See, I think, yeah, you're talking about a couple different things, because I think what we remember is that, I don't know, when did Terry McAuliffe even know the year, but people's voting rights did get restored if they were a convicted felon. But that's separate and apart. Thank you. But that's different. Marijuana is a misdemeanor unless it's a larger quantity. Then it could be a felony. But it's what Jim's talking about, and the law that changed about decriminalizing it are for misdemeanor possession charges, right? And that doesn't affect personal possession. It doesn't affect voting or anything at all.
Well, I know that, like I said, Charlottesville is behind in a lot of cities, but if marijuana is illegal here, but it's okay, like in California, isn't the government taxing that like they did liquor, alcohol?
So my son goes to school in Colorado.
Mm-hmm.
Here we go.
And I've had an opportunity to visit Colorado on many occasions to see him.
Uh-huh.
And the university he went to has beautiful new buildings built on
tax base.
Yes. Yes, ma'am, I hear you. I think we should legalize it here because I think it has lots of other benefits.
All right, that might be a good place to stop.
Good space to stop on marijuana.
We have one panelist who's 100% in favor of legalization and has family experience